morning, everyone, and welcome to the Association Health Plans Department of Labor Final Rule webinar. My name is Connie Ackridge. I'm a partner with the Holland & Hart Law Firm. And welcome everyone here today. Apologize for those of you who tuned in to the webinar last week, which we had to abort due to technical difficulties, but welcome back, and apologize again for that, for whatever inconvenience that caused you. But today we're going to be talking about the Department of Labor's final rule regarding association health plans, which was issued on June 19th of this year as a new regulation under 29 CFR section 2510.3-5. And this final rule was issued in response to President Donald Trump's October 12, 2017 executive order entitled Promoting Healthcare Choice and Competition across the United States. And this executive order stated that it should be the policy of the executive branch, to the extent consistent with law, to help facilitate the purchase of insurance across state lines and the development and operation of a healthcare system that provides high-quality care at affordable prices for the American people. And it specifically talked about how the Patient Protection and Affordable Care Act, which I will call the Affordable Care Act, or ACA, has severely limited the choice of healthcare options available to many Americans, and has produced large premium increases in many states' individual markets for health insurance. The executive order notes that the average exchange premium in 39 states that are using the www.healthcare.gov in 2017 is more than double the average overall individual premium recorded in 2013. It also notes that the Affordable Care Act has largely failed to provide meaningful choice or competition between insurers, resulting in a third of America's counties having only one insurer offering coverage on their applicable government-run exchanges in 2017. So the executive order identifies three areas of improvement, and the one we're going to be talking about today is number one, expanding access to association health plans to help small businesses and working owners band together to self-insure or purchase large group insurance so as to compete with large employers. And the executive order states that because large employers are able to obtain better terms on health insurance for their employees than small employers because of their larger risk pools, and also they can spread administrative cost and also get economies of scale in contracting with healthcare providers, there will be more advantages for them under a revised association health plan rule than there currently are, and which will also, according to the executive order, make the coverage more affordable and provide more options to many Americans, including hourly wage earners, farmers, and employees of small businesses and entrepreneurs that fuel economic growth. So the other two areas of improvement that were identified in the executive order, which we won't really talk about today, are short-term limited duration insurance plans, for which a proposed rule has been issued in February. The comment deadline was in April, and the final rule is expected any time, and also health reimbursement arrangements. So today we're going to be talking about the Department of Labor's existing sub-regulatory guidance on association health plans, and also the current status of state regulation just generally of association health plans and multiple employer welfare arrangement, MIWAs. We'll talk about, we'll give you a summary of the Department of Labor final rule, and we'll talk about some concerns that have been expressed about the final rule and a challenge litigation that's been filed to basically block enforcement of the final rule. During the rulemaking process, after the proposed rule was issued, the Department of Labor received some 900 comments to the proposed rule. Many of those comments it discusses in the preamble to the final rule, and there's a lot of insight in the final rule about why certain comments that were proposed, that changes to the proposed rule, were considered by the Department of Labor and either accepted or, for the most part, not accepted. And finally, we'll talk about opportunities created by the final rule. One very important piece in sort of understanding how the final rule fits into the existing sub-regulatory guidance is that it doesn't supplant the current guidance, so that what you have is essentially a dual track, where if you are an existing association health plan operating under the existing sub-regulatory guidance, there is no obligation for you to now abide by the final rule. You can still choose to operate under the status quo, which means that, or you can choose to follow the final rule. So there are staggered applicability dates for the final rule. September 1st for fully insured association health plans to become in compliance. January 1st, 2019 for existing self-insured association health plans to comply, and then finally April 1st, 2019 for new self-insured association health plans to comply. So forming a single employer MIWA under the DOL existing regulatory guidance, some consider the biggest benefit under the existing sub-regulatory guidance is that association health plans may set premium rates employer by employer based upon claims experience of each employer, which is prohibited under the final rule. However, one of the factors that may convince a current association health plan to switch over to operating under the final rule, assuming they can comply with all the criteria and qualify, is that relying upon the sub-regulatory guidance, relying upon the facts and circumstances analysis by the Department of Labor instead of a more precise final rule could be problematic. I think I skipped a slide, okay. So essentially, under ERISA, employee benefit plans, group health plans sponsored by individual employers, the number of employees determines whether the Affordable Care Act small group market rules apply or whether the large group market rules apply. So the small group market rules include the requirement that the plan offer essential health benefits and apply adjusted community rating in setting the rates. So just a little background on essential health benefits. Probably most of you know, but essential health benefits ensure that everyone in the individual and small group health insurance market has access to comprehensive coverage. So the essential health benefits include benefits that fall into 10 main categories, including ambulatory patient services, emergency services, hospitalization, maternity and newborn care, mental health and substance use disorder services, including behavioral health treatment, prescription drugs, rehabilitative and habilitative services and devices, laboratory services, preventative and wellness services, and chronic disease management, and pediatric services, including oral and vision care. So small groups have to offer essential health benefits to their insureds, and also they must apply adjusted community rating. Community rating is a method for setting premiums so that the risk is spread evenly across the community, with all individuals paying the same rate, regardless of their health status or other factors such as age, gender, and lifestyle characteristics. When the Affordable Care Act became the law beginning in January 2014, it required adjusted community rating for non-grandfathered policies in the individual and small group insurance market. Most large, fully insured and self-funded employers are exempt from this requirement. So under the Affordable Care Act's adjusted community rating provisions, the use of actual or expected health status or claims experience to set group premiums is prohibited. Health insurance issuers may vary the premium rate charged to specific non-grandfathered individual or small group from the rate established for that particular plan only on the following factors: family size, individual or family, geography, rating area, age, a ratio of 3:1 for adults, and tobacco use within a ratio of 1.5 to 1. Therefore, although groups of employers may come together under the current sub-regulatory guidance to form a single employer association health plan, the specific strict rules developed by the Department of Labor under their advisory opinions require that members must be of a bona fide group or association with a commonality of interest beyond the provision of health benefits, and must exercise control over the administration and management of the association health plan, and the employers must be in the same industry. So otherwise, if, and also the DOL uses advisory opinions and court decisions use facts and circumstances to review, to determine whether a bona fide group or association exists. And so the facts and circumstances test is focused on whether employers share some employment-based relationship or genuine organizational relationship separate from the provision of insurance, and whether the employers that participated in the benefit program exert control over the program in both form and substance. So from a historical standpoint, because of the strict guidance, DOL has found that very few MIWAs could be treated as single employers and therefore dealt with at the plan level. Most association health plans are dealt with at the employer level, which means that the Department of Labor uses what they call the look-through doctrine to look at the size of each employer group in the association health plan to determine whether or not the small group rules, which are those applicable to 50 or fewer employers, or the large group rules would apply. So, so as I was saying, when I skipped over, I went to this slide inadvertently. The biggest benefit, that most people believe the association health plans enjoy under the current sub-regulatory guidance is they're able to set premium rates employer by employer based on claims experience, which is disallowed under the final rule, and also because of the subjectivity of the facts and circumstances analysis by the Department of Labor. There may be some thought that it's better for an existing association health plan that can comply with the final rule and meet the criteria to become a bona fide group to move to be governed under the final rule. So states vary in terms of their regulation of MIWAs under state law. Now, under ERISA, states may not fully regulate MIWAs because because ERISA preempts all laws, state laws relating to employee benefit plans. However, under the savings clause, nothing in ERISA, quote, shall be construed to exempt or relieve any person from any law of any state which regulates insurance, banking, or securities. So, as I was saying, there's a variety of ways that states regulate MIWAs, which I think adds to the confusion about what state laws exactly comply. Now, some states regulate MIWAs almost like a commercial insurer. In Nevada, for example, it regulates MIWAs as it requires them to be authorized, have a certificate of authority as a health insurer, and comply with all of the other solvency requirements. And so some states, however, don't have that level of regulation. Some other states, do have the same sort of strictness that Nevada does in terms of regulating MIWAs. So it can vary, and I think that, as I said, I think that the variability, that there's no standard format for regulating MIWAs under state law can provide opportunities for people who may want to start an association health plan for fraudulent reasons. So under the final rule preamble, essentially what it says is that the way that states were regulating MIWAs under the current DOL regulatory guidance will remain the same. And if an association health plan is self-insured, any state law that regulates insurance may apply to the association health plan to the extent such law is not inconsistent with ERISA. Doesn't modify, the final rule doesn't modify or otherwise limit existing state authority established under 514 of ERISA to regulate MIWAs or association health plans. and indicates that under Section 514B6 provides the Department of Labor with authority to preempt state law insurance laws that go too far in regulating self-insured association health plans in ways that interfere with the final rule's important policy goals. So just sort of a little reminder there that although states have the authority to regulate insurance, there are some authority that the DOL has to preempt state law insurance laws that go too far. So some states, as I said, it varies from state to state, but some states have true group association statutes that require an association to be formed for a purpose other than providing health insurance coverage to be eligible to form a MIWA, or may require the association to be in existence for a certain period of time before the association may offer insurance to its members. It's interesting to think about whether or not these state provisions that have those sorts of requirements are now, these requirements now preempted by the final rule. Thought it was interesting that on June 27th, 2018, the New York Department of Financial Services issued a circular letter, and I think this recommend that for you to look at that, but it essentially is a letter letting the industry know that the final rule does not preempt New York insurance law, which strictly limits associations or groups of employers that may sponsor a health insurance plan, that they, under New York law, those plans, self-funded association plans, are required to be licensed to do insurance business in the state, regardless of where their self-funded association is located, and are subject to New York requirements such as solvency, premium rate review, state benefit mandates, and consumer protections. Any entity that violates New York law is subject to monetary penalties and also may be subject to a cease and desist order. It also warns that any person who solicits, negotiates, or effectuates any coverage on behalf of an unlicensed and unauthorized self-funded association may be in violation of New York law and be subject to penalties as well. So it seems to be some concern in New York anyway, and I believe in other states as well, that were expressed in the comments to the proposed rule, that the final rule may be used by some who now think they have authority to go forward without considering state regulation and form an association health plan under the final rule. So I think that this concern sort of, I think, is due to the amount of fraud that has been historically occurred with respect to MIWAs and persons who weren't associated with employer groups but just wanted to sell insurance and collect premium, have left a number of health plans without any premium dollars to pay claims, have left the state, left insurance regulators holding the bag. And so I think there's a concern on the behalf of the state regulators where this final rule may lead in terms of their being vigilant in and making sure that their state laws are followed in persons who want to implement association health plans in their state. So the objectives of the final rule are really to remove restrictions on the establishment of the association health plan and create a more flexible commonality of interest test under Title I, Section 3.5 of ERISA for determining when an association of employers will be treated as an employer sponsor of a employee welfare benefit plan or group health plan. It allows working owners without common law employees to be both an employer and employee. So under the final rule, working owners genuinely engaged in trade or business, which is an ownership right of any nature in a trade or business, whether incorporated or unincorporated, and who's earning wages or self-employment income from the trade or business for providing personal services to the trade or business for an average of 20 hours per week or 80 hours per month, or has earned income from such trade or business that at least equals the working owner's cost of coverage for participation by the working owner and covered beneficiaries in the group health plan. So plan fiduciaries under the final rule have a duty to determine, reasonably determine the eligibility, that this eligibility condition is met for working owners to be able to participate. The other stated aims of the final rule are to expand access to affordable health care to small employers and self-insured persons, working owners, not only that, but making it easier for them to join together to create associations to sponsor large employer group health plans free from the Affordable Care Act individual and small group insurance plan mandates, and also allow associations of small employers and self-insured employers sponsoring an association health plan, the same kind of benefit package design flexibility, reduce costs due to increased bargaining power with providers in the facilities, economies of scale and administrative efficiencies that large group employers enjoy. So that's really one of the primary objectives. The final rule makes preamble makes a number of mentions of its rationale and why it makes particular determinations about what the final rule looks like. Necessary to draw a line between traditional health insurance issuers, which typically exist only to underwrite and sell insurance on the one hand, and association health plans that qualify as an employer under Section 3.5 of ERISA on the other. And recognizes that that protections are necessary to prevent fraud and abuse and prevent entrepreneurial MEWAs from being able to establish a bona fide group with access to large group treatment. So the laws, so ERISA is the underlying law that permits the formation of association health plans. Employee welfare benefit plan or group health plan is defined. Basically allows employers to offer coverage, offer employee welfare benefit plans, group health plans under ERISA. And the term an employer, the definition includes a group or association of employers acting for an employer in such capacity. So one of the big things that the final rule did was eliminate the look-through doctrine, which we talked about earlier, so that now, assuming the group meets all of the criteria under the final rule, assuming there are sufficient number of employees in the association health plan to constitute a large group, and that's at least 50 employees, then the Department of Labor will no longer look at each individual group to determine whether or not, and the size of each individual group to determine whether the coverages should be subject to small group or large group market rules. That if it's a large group, if the total group is bigger, has at least 50 employees, then it will be deemed to be a large group, and the large group market rules will apply. So now I'm going to go through the 9 criteria that are necessary to establish a bona fide employee association qualified to sponsor an association health plan. So one of the things that's required is there must be a substantial business purpose unrelated to the provision of health benefits. So the substantial business purpose, the bona fide group or association must have at least one substantial business purpose. That term is not defined. Unrelated to the provision of health benefits. The group or association's principal purpose may be the provision of health benefits. And there's a safe harbor. A substantial business purpose is deemed to exist when a group or association could be a viable entity without sponsoring an employee benefit plan. And the substantial business purpose includes promoting members' common business interests or trade or employers' common economic interests. And the rule says that evidence of a substantial business purpose exists if prior to sponsoring an association health plan, the group or association operated with an active membership. It also says that the substantial business purpose does not have to be for profit. In fact, the group organization may be a tax-exempt organization with a purpose unrelated to sponsorship of the association health plan if it meets all such requirements for exempt status. It also, the rule also says that, the regulation also says that to satisfy the substantial business purpose, the association could offer other services to its members, such as convening conferences or offering classes or educational materials on business issues of interest to the association members, act as a standard-setting organization that establishes business standards or practices, engages in public relations activities such as advertising, education, and publishing on business issues of interest to association members unrelated to the sponsorship of the association health plan. It could be their purpose could be advancement of the industry in which members operate, although in the case of a group or association, that would need to it would need to advance the well-being through substantial non-health coverage activity. A pre-existing group or association could create a wholly owned subsidiary to administer an association health plan, even if the subsidiary exists solely to administer the group health plan. So in that instance, the group or association's substantial business purpose, unrelated to the provision of health care, is not eliminated by its decision to create a subsidiary under its control to administer the association health plan. The second criteria is that each employer member of the group or association must act as the employer of at least one employee who is a covered participant in the association health plan. The third criteria is that the association must have a formal organizational structure. So it's got to, and the Department of Labor agreed with commenters who gave comments regarding the proposed rule, who said that the existence of a formalized and robust organizational structure could be an important form of protection against fraud and insolvency, and the Department of Labor agreed and put in and established this requirement that there be a formal organizational structure. Number 4, the employer members must have control over the association health plan in form and substance. So what this requires is the employer members have to control the group or association's functions and actions, but they're not required to control or manage the day-to-day affairs of the association. So the following non-exclusive factors are relevant for determining whether the employer members exercise sufficient control to qualify as bona fide. Whether the employer members regularly nominate and elect directors, officers, trustees, or other similar persons that constitute the governing body or authority of the association and plan. Whether the employer members have authority to remove any such director, officer, trustee, or similar person with or without cause, and whether the employer members that participate in the plan have the authority and opportunity to approve or veto decisions or activities which relate to the formation, design, amendment, and termination of the plan. For example, are they involved in material amendments to the plan, including changes to coverage, benefits, and premiums? And the rule said that the fiduciary status of the group or association's key officials or board members is entirely irrelevant to whether the group or association members exercise the necessary control. The next criteria to establish a bona fide employer, association qualified to sponsor an association health plan is whether or not the employer members have a commonality of interest. And there must be a commonality of interest among employer members to sponsor an association health plan. The commonality of interest may be established by the employer members that are in the same trade, industry, line of business, or profession, or have a principal place of business in the same region that does not exceed the boundaries of a single state or metropolitan area, even in the metropolitan area includes one or more states. So that second way to qualify to achieve commonality of interest by having a principal place of business in the same region that does not exceed the boundaries of a single state is not industry specific. So that could be used by, for example, various chambers of commerce to create an association health plan under that rule, even though they have members with varying, who are involved in varying industries. A subset of trade, industry, or profession is permitted, and groups and associations have substantial flexibility to cover segments of a geographic area that otherwise satisfies the definition of commonality of interest, as long as the subset or segmentation are not a smokescreen for discrimination based on a health factor. In the case of a group or association sponsoring a group health plan and is itself an employer member of the group or association, the group or association will be deemed for purposes of the commonality of interest standard to be the same trade, line of business, or profession as the other employer members of the group or association. So I think in the final rule, the Department of Labor predicted that sort of larger groups would likely be formed with the geographic commonality of interest standard, and there would be an opportunity greater opportunity to achieve the administrative efficiencies, bargaining power, et cetera, that large groups currently enjoy. The sixth criteria to establish a bona fide employer association qualified to sponsor an association health plan. There must have there must be limited participant eligibility. So eligible participants only include an employer member's current employees, current and members, former employees who were entitled to coverage under the group's or association group health plan during their employment, and beneficiaries of such individuals, spouses, and dependent children. When applicable, an association health plan must provide eligible persons with continuation coverage and certain other post-employment coverage. And even though suggested by a number of commenters, the Department of Labor declined to include any specific open enrollment period requirements. Okay, sorry. The seventh criteria to establish a bona fide employer association qualified to sponsor an association health plan requires that the group or association health coverage has to comply with HIPAA non-discrimination provisions. So group health plans, including association health plans, are subject to HIPAA non-discrimination rules. Under the final rules non-discrimination provisions, groups or associations are prohibited from basing membership, eligibility for benefits, and premiums on any health factor, including but not limited to health status, condition, and claims experience of employees. Association health plans cannot treat employer members as distinct groups of similarly situated individuals based on a health factor. And association health plans may distinguish between employer members based on factors other than a health factor, such as a bona fide employment-based factors, including geographic location, occupation, and industry. And age and gender are not considered health factors. So commenters under the rule urge the Department of Labor to maintain the employer by employer ability to experience rate, making a number of arguments that if that wasn't the case, the association health plans would be unstable and would lead to failure. One commenter argued that failing to allow some risk adjustment mechanism from employer to employer group would disincentivize large employers whose plans can be experience rated from participating in an association health plan unless their risk pool is significantly sicker than that of the association health plan. And some were concerned that as association health plans, that the ability to experience rate each member employer, without that ability, association health plans would be left to compete with other coverage options on the basis of benefits, such as by offering less generous benefit packages to achieve lower prices. And some were concerned that if they weren't able to experience rate, that their ability to establish wellness programs would be impeded. Despite all those comments, the Department of Labor decided that it wouldn't allow experience rating from employer to employer, and instead it gave in the preamble to the final rule 10 examples of how the non-discrimination rules would work to give people an idea of exactly what they could and could not do. So I'm going to go through a few of those examples very quickly. In the first example, you have an association that offers group health coverage to all of its members. All members, subject to the following criteria, all members must be restaurants located in a specified area. The example is you have a restaurant which is located in the specified area, has several employees with large health claims. And the question is, if restaurant fee applies for membership in the association and is denied membership, is that, based upon claims experience, could that association be a bona fide association? And the answer is no, that clearly is violative of HIPAA's non-discrimination rules. The second example has an association which offers group health coverage to members having their principal place of business in a specific metropolitan area. And they have an example of a sole proprietor whose principal place of business is within a specified area. And as part of the membership application process, this sole proprietor provides certain health information indicating that he has diabetes. So the issue is, can the association deny the sole proprietor membership because of his diabetes? And the answer is that no, that would be a violation of HIPAA's non-discrimination rules. It would not be consistent with qualifying as a bona fide employer. The third example is that an association offers group health coverage to all plumbers working for plumbing companies in a state, assuming if the plumbing company employer chooses to join the association. So the question is, may the plumbers discriminate in rating as between part-time workers and full-time workers? And the answer is yes, that distinction is permitted distinction between similarly situated individuals under the HIPAA non-discrimination rules. The next example, the association chart sponsors a group health plan available to employers doing business in a particular town. So the association charges a particular business in that town more premiums than it charges other members because that business employs several individuals with chronic illnesses. That would not be allowed as a because it's based upon health factors, and it would be violative of HIPAA's non-discrimination provisions. The fifth example, you have an association that sponsors a group health plan available to its members. It's open to any entity whose principal place of business is in state K, which has only one major metropolitan area, which is its capital city. So members whose principal place of business is in the capital city of state K are charged more for premiums than members whose principal place of business is outside the capital city. And the guidance says that that distinction is permitted between similarly situated individuals because it's not based upon a health factor. There's another example where an association sponsors a group health plan. Membership is open to any entity whose principal place of business is in a particular state. A sole proprietor whose principal place of business is in a city within that state is the only member whose principal place of business is in that particular city, and it is otherwise similarly situated with respect to other members of the association. After learning the sole proprietor has been in that particular city has been diagnosed with cancer, the association changes its premium structure to charge higher premiums for members of the city in which the sole proprietor resides. That's a distinction between groups similarly situated on its face based on geography, but which is not a health factor, but that's directed at one or more individuals based upon a health factor, cancer. In this case, a distinction directed at an individual is not permitted distinction. But there is variability in rates allowed if you have, for example, an agricultural industry association that sponsors a group health plan that charges employers different premiums based upon their primary agriculture subsection, such as crop farming, livestock, fishing, and agriculture and forestry. That's a permitted distinction. If you're in the retail industry and you charge employers different premiums based upon their occupation, cashiers, stockers, sales associates, that's not directed at individual participants or beneficiaries based on health factor. That's okay. And if you have a health plan that's available to all employees with a principal place of business in a particular state, employers charge different premiums based on their industry subsector defined under the terms of the plan, as, for example, construction, education, health, financial services, information services, leisure and hospitality, and manufacturing, transportation, natural resources, and other. That's okay, and so is allowing different premiums to be charged for part-time versus full-time services. Those are all permitted. And then the final example is allowing a premium discount to participants who participate in a wellness program that complies with Section 2590.702F, and that's permissible. So those are just to give you, some ideas under the rule of what exactly is allowed in terms of complying with these non-discrimination rules. Now, the eighth criteria to establish a bona fide employer association qualified to sponsor an association health plan is that health insurer issuers may now sponsor an association health plan. Health insurance issuers, these are health insurance companies or other entities owned or controlled by health insurance companies, are prohibited from sponsoring association health plans. They may not participate as an employer member of a bona fide association of insurers that sponsors an association health plan. Groups or associations controlled by entities that are part of the U.S. healthcare delivery system, including network providers and healthcare companies, don't qualify as bona fide groups or associations. But a health insurance issuer or other business entity that's part of the U.S. healthcare delivery system may provide certain services to the association health plans, including administrative services, provider and pharmacy network design, record keeping, reporting, and disclosure services, wellness program administration, 24-hour nurse helplines, audit services, and/or association health plan setup assistance. And that's all with this whole concept that to keep commercial insurance and folks that are engaged in the transaction of a commercial insurance separate from employer association health plans that are governed by bona fide employer associations. Now, there have been a number of concerns expressed by about these association health plans in the proposed rule and the final rule, and there have been challenges to the proposed rule, or actually to the final rule. So in the final rule, that, as I said, the Department of Labor responds to many of the 900 comments it received in response to its January 5th, 2018 proposed rule. And while the Department of Labor expresses its view that the final rule adequately protects plan participants and beneficiaries from fraudulent arrangements, and a number of the commenters, however, weren't convinced, and many of the articles that you see in the press today still have a lot of skepticism about how adequately the final rule protects consumers and potential association health plan members from those who want to commit fraud. So as part of the final rule, it said that the anticipating that the association health plans will provide more affordable coverage, the Congressional Budget Office predicts that an additional 4 million people will enroll in association health plans. So some predicted that the final rule will destabilize the insurance market by siphoning off young, healthy insureds from the Affordable Care Act individual and small group markets, causing premiums to increase for those who remain. The day after the adoption of the final rule, New York and Massachusetts Attorney Generals announced their intent to bring an action to block implementation of the final rule, which they say will result in fraud, mismanagement, and deception. So on July 26th, just last week, AGs from 11 states and the District of Columbia filed a complaint in the United States District Court, District of Columbia. They basically say that the final rule, the complaint, is an interesting read. The final rule is part of the administration's broad effort to undermine the Affordable Care Act, the additional reforms that Congress enacted for individual and small markets, since those markets are more prone to abuse, including discrimination in pricing and benefits, will be entirely eliminated by the final rule. So essentially, what they're saying is you have an agency making rules that undermines legislation that was passed by Congress, and that really no good can come of the final rule, and that Congress has a long history of rejecting legislation that expands access to association health plans. So we'll see what happens with that lawsuit as time goes on, whether or not it will be resolved prior to the April 1st start date for new association health plans. But there are opportunities under the final rule. Associations who are currently maybe not able to meet bona fide association status under the sub-regulatory rules can convert to an association health plan under the new rules, which are more flexible and may allow more flexibility for those associations to form association health plans, more expansive as well. Groups not in the same industry may now form geographically, which they were not able to do before. Health insurers and other service providers, third-party administrators, utilization review agents, and the like may find more opportunities to provide services to association health plans. And the alternative risk industry may want to consider forming association health plans under the new rules for members that they serve. So that's all I have today for this webinar. Thank you so much for your attention. Appreciate it. Thanks so much.